for the hospital. And as Mr. Moore and Mr. Russell have said, the hospital is in support of this project, but we have serious concerns with the process, and we object to the eminent domain procedure. Now, number one, we object on the grounds that the notice that was provided by RK Height is insufficient. The statute provides that the notice has to come from the village, not your consultant. That's how we receive notice, so first off, we believe the notice is deficient. Number two, for eminent domain purposes, there is no public benefit to this project. The hospital understands, outside of the eminent domain procedure, why this is important. But for eminent domain purposes, there is no public benefit, and therefore, eminent domain does not apply. Third, and very importantly, if the village goes down the path of trying to take this property by eminent domain, they have to pay the hospital. That cost could be well in excess of $500,000. The project cost right now is $1 million. So you're looking at adding 50% of this project cost to the bottom line. The hospital offered in July of 2011 to grant the easement at no cost or expense to the village, provided that the board of directors approved it, the necessary state approvals were obtained, including Department of Health, court approval if necessary, and other certain conditions approved by me as their counsel. We never received a response to that letter. That letter was to Mayor Terry Round. We are unaware of any appraisals that have been conducted, and based on what Nancy Mullen has said, there are none at this time. Next, we don't know if any detailed analysis has been conducted from an environmental standpoint, a Department of Health standpoint, or a Homeland Security standpoint. I'd like to touch on the Department of Health issue. We're licensed by Article 28 of the Public Health Law. We cannot deviate from our license requirements. Every deviation needs to go to the Department of Health. If we don't go to the Department of Health, our license is at issue, meaning we cannot treat patients in the village. That would be a huge, huge mistake, and it would be a costly mistake for the residents and tourists of this area. We need to make sure the emergency dock access is not impeded in any way. Now, lastly, the eminent domain procedure law contemplates that the village actually work with the property owner. As we've said, we've sent this letter and we never received any response. We're asking going forward that we are communicated with on a regular basis, that all of our concerns are met from a licensing standpoint. I'd also like to ask that the meeting be held open for a period of a couple weeks so we can submit our written responses to Mr. Gibo and the board. And we're reserving all of our legal rights at this time, including, if necessary, having to commence an Article 78 proceeding. Thank you.